Well, in this case, the canteen, this is a matter related to canteen workers.
Yes.
But if your lordship kindly takes up now, 1989 SSC Online Calcutta 163.
Yes.
Here also, my lord, the Food Corporation of India Workers Union versus the Food Corporation of India was put into test, my lord, against the order of the tribunal, wherein this honorable court was pleased to hold that the petitioner should succeed in the writ petition. The writ petition is disposed of by directing the respondent to recognize the petitioners number 1 to 158 as direct employees of the Food Corporation of India. The salary and the benefits of the petitioner should be fixed in accordance with
The paragraph number?
paragraph number 8. Here also,
Are you in a hurry?
no,
Why are you not referring to the paragraph number, taking it slowly? You are reading on your own. How will I apply my mind?
yes, my lord. Well, here the case was the petitioners were 158 in number. Number the petitioners were also engaged in loading and unloading, handling and transporting of food materials in the godown of the Food Corporation of India and at the different railway sidings and yards, and are doing their other ancillary works.
Paragraph 8, accordingly, in my opinion.
Well, I'm just giving a gist of the matter. And paragraph 8 says that accordingly, in my opinion, the petitioner should succeed in the writ petition. The writ petition is disposed of by directing the respondents to recognize the petitioners numbers 2 to 158 as direct employees of the Food Corporation of India. The salary and benefits of the petitioner should be fixed in accordance with the rules and as per the existing pay structure of the Food Corporation of India. The Food Corporation of India will implement this order within 5 weeks and such and such minute.
Just a minute.
Here also the same issue was cropped up, my lord. আমি বলে দিয়ে দিচ্ছি আপনার সব
Yes,
My lord,
yes.
article. Your lordship now comes to, my lord, the Hindustan Petroleum. No, I have cited that. Yes.
Which one?
My lord, Justice Bopanna's judgment,
All right.
FCL loading and unloading workers. My lord.
Yes.
But this was passed by the Honorable Karnataka High Court. Again, the same issue cropped up.
This is
Whether-
an unreported judgment.
Yes, my lord. That is what
Indian law reports Karnataka. No, it's not unreported. ILR Karnataka.
but here also the issue was whether the persons employed by the contractor would be held to be a workman with the principal employer.
Hmm.
For the paragraphs number
29.
workman employed, my lord, paragraph 29 of the judgment. My lord. In the result, the writ petition is allowed, and there are directions to treat the workman employed by the respondent to
Which
on
page
such-
is paragraph 29 on?
last page, my lord, 2619.
Yes.
To treat the workman employed by the respondent number 2 as on 28th February 1986 as its workman on the same terms and conditions of service as mentioned in Annexure A and B to the writ petition. If for any reasons the corporation intends to retrench these workmen, the statutory requirement under section 25N and F of the ID Act shall be complied with, and other relevant provisions. my lord. And my lord, this is an unreported judgment of 2023.
Just a minute.
ওটাই বলছি। Oh, 15, 15,
Yes, yes.
But now if your lordship kindly takes up the unreported judgment of the honorable.
Only the last paragraph you're referring.
But there are other paragraphs also, my lord.
So according to you, which are the relevant paragraphs? Quickly tell me. Mr. Chattopadhyay, kindly make a note of these judgments
Sir, I'm
because
asking
you have to
for-
distinguish them.
I shall distinguish them.
I have handed over them the written notes, including the judgments which I have cited.
I have
before
just
your
now
lordship.
received, but I shall.
Even I'll give them a copy of it also. Well, if your lordship kindly comes to the unreported judgment of the Honorable Supreme Court.
Yes,
2020
yes.
2023. This issue here was slightly different. Here, the workmen were reinstated. Again, that was challenged before the tribunal. And that went up to Supreme Court, and the Honorable Supreme Court in paragraph 15. Civil appeal. That after considerable period of time, when their work was accepted by the FCI, they cannot challenge the award. Now, this order was passed in 2006. After a considerable period of time in 2023, but this matter is being finally heard. But may I read paragraph 15 minute?
Paragraph?
15. In the case on hand, the management of FCI filed a writ petition challenging the award passed by the tribunal having secured conditional interim relief therein. The management chose to implement the impugned order, though it was under no compulsion to do so. As pointed out herein above, the management did not stop short at just reinstating the workmen in service, but went further and absorbed them in regular service. Such absorption in service was not at all required under the interim order dated 5/8/1999 and was therefore squarely attributable to the will and volition of the management of FCI itself. In effect, the management of FCI, be it for whatever reasons, chose to acquiesce with and accept the award in its entirety, though it made such compliance subject to the result of the writ petition. In solemnance thereafter, in taking timely measures for expedite disposal of the writ petition, compounded the matter further, leading to the passing of 18 long years, which conclusively weighed with the learned judge, and in our considered opinion, rightly so. A party to the proceeding cannot be permitted to challenge the same but after abide by it out of its own will, garner benefit from it, get the opposite party to effectively alter its position, and then press for its challenge after the passage of considerable length of time.
So how is this aiding you?
But aiding in the sense, my lord, but the reconciliation failed. Till reconciliation, there was a settlement whether
The entire thing proceeds on the basis that it has not been challenged for a long period of time.
my lord,
And they have gone ahead and reinstated and they have not challenged for more than 15 years.
my lord, what I'm submitting, my lord, that for 18 years they have worked. Now reconciliation was called for, that whether these people will be reinstated or not. Now, my lord, my submission is that
Where has Food Corporation gone ahead and absorbed these people? Over here, Food Corporation has not only absorbed them, but also regularized them.
my lord, but if they are reinstating or engaging some other persons, but my humble submission, what illegality has these people done? They could have been
That
regularized.
is a separate issue. That is a separate, first you prove your legal right. See, in most of these cases, the second hurdle is not there.
My lord,
It is accepted that these people are working.
but
So the second hurdle that you have to cross is not there
whether
in the other
the
two
persons were
decisions.
there or not, the list of names.
In the other two decisions. And in this decision is very different. This
Yes,
was
ma'am.
on the question of if you challenge an award belatedly after giving effect to that award. That this is a different, it proceeds on a different perspective altogether.
But if your lordship kindly sees, my lord, the order of Justice Sen, here also the situation was similar. 2 to 158 people were working under employer. The situation was that the contractor kept on changing, but the
Yes,
work
there
was
is no
done.
dispute with regard to the names of 2 to 158 contractors.
But-
That is the second hurdle that you have to cross. Anyway, show me the next decision.
But here the hurdle was also that if there is no evidence on the part, it has to be constituted in favor of the weaker section.
All right.
Nothing else, my lord. I would not.
What about the rest three?
But that is Uma Devi absorption, my lord, your lordship knows, my lord. I'm not troubling with it.
Uma Devi, yes.
Regularization and absorption. my lord. And one is Air India, the 5-bench, 3-bench, my lord, 1987.
What for have you cited this?
Uh, '65, yes. 65, 69. 65 and 69. কোথায় গেল ওটা? না ওখানে দেখবি, ঠিক আছে চলে যাবে। मतलब पेज paragraph 69 मतलब
Paragraph
69 of the judgment of 1997 9 SSC 377. But may I read that?
yes.
Now the moot question is as to what happens after such prohibition. It is obvious that prior to abolition, the contract labor doing work of perennial nature on the establishment of principal employer had the advantage of regulatory provisions found in chapter 4, and these provisions were given teeth by the legislature in chapter 6 by providing for penalties and procedures for imposition of sanctions by prosecution. The question is whether after abolition of the contract labor system, the contract laborers who were earlier having regulatory protection would be rendered persona non grata and would be thrown out from the establishment and told off the gates. Then in such a case, the remedy of abolition of contract labor would be worse than a disease, and it has to be held that the legislature, while trying to improve a lot of erstwhile contract laborers who are doing work of perennial nature for the principal employer and are doing work which is otherwise to be done by a regular workman, had really left them in the lurch by making them lose all the facilities available to the contract labor on the establishment as per chapter 5 and desired them to wash their hands off the establishment and to get out and face starvation. It is axiomatic that if they continued to be contract laborers, their wages would be have guaranteed under section 21 of the act, with an obligation on the principal employer to pay them if the contractor fails to discharge his obligation in connection with the payment of wages. Wages are the livelihood of a workman and his large number of dependents. If on abolition of contract labor system, contract labor itself is to be abolished, it would cause economic ruin and economic death to the contract labor and his dependents, for amelioration of whose lot order under section 10 is to be passed. If it is held that on abolition of the establishment, lock, stock, and barrel, it would amount to abolition of the contract labor system, the erstwhile contract laborers are to be thrown out of the establishment, lock, stock, and barrel. It would amount to throwing the baby out of the bathwater. That obviously cannot be the scope and ambit of section 10 of the act. It has to be kept in view. The contract labor system is an establishment in a tripartite system. In between contract workers and the principal employer is the intermediary contractor. And because of his intermediary, the employer is treated as principal employer with various statutory obligations flowing from the act in connection with regulations of the working conditions of the contract laborers who are brought by the intermediary contractor on the principal establishment for the benefit and for the purpose of principal employer, and who do his work on the establishment to the agency of the contractor. When these contract workers carry out the work of the principal employer, which is of the perennial nature, and if provisions of section get attracted, such contract labor system in the establishment gets abolished on fulfillment of the conditions requisite for the purpose. It is obvious that the intermediary contractor vanishes, and along with him vanishes the term principal employer. Unless there is a contractor agent, there is no principal. But here Tarapada Ghosh was the contractor in between, under whom these 254 people were working, which is not denied by them also. Once the contractor indemnity goes, the term principal also goes with it. Then remain out of this tripartite contractual scenario only two persons: the beneficiary of the abolition of the erstwhile contractual labor system, that is the workman on the one hand, and the employer on the other, who is no longer the principal employer, but necessarily becomes a direct employer for those erstwhile contract laborers. It is urged that Section 10 now nowhere provides for such contingency in express terms. It is obvious that no such express provisions was required to be made, as the very concept of abolition of the contract labor system, wherein the work of the contract labor is of perennial nature for the establishment and which otherwise would have been done by the regular workman, would possess improvement of the lot of system of such workmen and not its worsening. Implicit in the provisions of Section 10 in the legislative intent that on abolition of the contract labor system, the erstwhile contract workmen would become direct employees of the worker on whose establishment they were earlier working and were enjoying all the regulatory facilities on the very establishment of under Chapter 5 prior to the abolition of the contract labor system. Though the legislature has expressly not mentioned the consequence of such abolition, but the very scheme and ambit of Section 10 Act of the Act clearly indicates the inherent legislative intent of making the erstwhile contract laborers direct employees of the employer on abolition of the intermediary contractor. It was contended that the contractor might have employed a number of workmen who may be in excess of requirement, and therefore the principal employer on abolition of the contract laborers may be burdened with excess workmen. But there might be the issue where the number did not match with them, hence the reconciliation failed. But as of now, Mother Tarabhadra Ghosh is in admitted position who was working as a storing agent and under whom I was working. It was contended that the contractor might have employed large number of workmen who may be in excess of the requirement, and therefore the principal employer on abolition of the contract labor may be burdened with excess workmen. It is difficult to appreciate this contention. The very condition engrafted under Section 10 2D shows that while abolishing contract labor from the given establishment, one of the relevant considerations for the appropriate government is to ascertain whether it is sufficient to appoint constant number of full-time workmen. Even otherwise, there is an inbuilt safety valve in Section 21 of the Act, which enjoins the principal employer to make payment of wages to be given to the workers, to be given number of contract workmen who he had permitted to be brought for work of the establishment. If the contract fails, make payment to them. It is therefore obvious that the principal employer, as a worldly businessman, in his practical commercial wisdom, would not allow the contractor to bring large number of contract laborers, which may be in excess of the requirement of the principal employer. On the contrary, the principal employer would see that the contractor brings only those number of workmen who are required to discharge their duties to carry out their work of the principal employer on his establishment through, of course, the agency of the employer of the contractor. But here the Mr. Avani Mohan Bhattacharya, page 95, had admitted that their work was very essential, and without their contribution to work, the work in FCI could not be successful. For the rest, I'm not reading.
It's all right.
my lord, last one, my lord.
Yes.
For 2022 SSC Online, Calcutta 3038. Here,
Yes.
my lord, the issue was whether the driver who was working under the bank would be considered as direct employer of the bank or not.
Yes.
But paragraph 39, in this case, my lord, may I read, my lord? The tribunal had tried the issue as a preliminary issue. It had followed a proper procedure of allowing both the employer and the alleged employee to adduce evidence, both oral and documentary. It had been taken into account the evidence produced by both parties. In my opinion, this evidence was correctly weighed, analyzed and evaluated by the learned judge of the tribunal. The observation of the learned judge that if the bank had to prove that Mr. Sharma had paid the remuneration of the driver, he had been called as a witness, which the bank did not do so, was a very proper analysis and the interpretation of the evidence before it. Thereafter, the tribunal held on the basis of the evidence produced before it that the vehicle belonged to the bank. It was driven by the appellant for its employee, Mr. Sharma, and that the appellant had discharged his evidential burden. In the above facts and circumstances, the presumption could also be made that the appellant was an employee of the company, which would not refute the presumption or disprove that facts proved by the appellant. The appellant had, and the bank had failed to discharge the burden of its proof. The conclusion reached by the tribunal and the reasons in support thereof, in my opinion, most probable, reasonable, and far from purpose. But here the issue was upheld by the Honorable Division Bench, stating that the driver who was employed by the agent is also a direct employer of the bank.
Yes, but here it is admitted that there was a contractor in
My lord.
between. There, the
But-
bank was unable to prove that there was a contractor in between.
But here also, my lord, there was an,
Here it is
missing.
admitted that there is a contractor in between.
but the only issue is the number of workers, admittedly, because
Who are they, my lord? Number
Who
of
are
workers,
they?
who
That
are
is what I am asking him.
because
Because in all these cases, if you see what the courts have done, they have evaluated the evidence that the tribunal has evaluated. And they have seen whether there is any perversity in the decision-making process of the tribunal or not by looking into the evidence and the way the analysis has been made by the tribunal. In this case, in the present case at hand, what has happened is that the tribunal has held certain things in favor of FCI and then held that these people have to be reinstated. Now, there is a gap in that decision-making process that you have to address.
but the issues also that the back pages has also not been granted. But the passage of time,
Mr. Chatterjee, can you understand
Absolutely,
what
but
I am trying to tell
get-
you?
but I
So
get
that
what-
gap, please bridge that gap.
because the natural calamity has happened prior to which I cannot. But the natural calamity has washed away all documents. That is what the averment is. Now, my lord, weighing in favor of the appellant, in favor of the workers, but that was weighed by the Honorable Tribunal, my lord, on the basis of the witness that was examined. Because they have also admitted that they were working, they were there. Now, who are these people? That list is.
Take me to the order of the tribunal, award of the tribunal.
Page 137, my lord. Page 137.
Yes.
May I read, my lord? By order number L to such and such, dated such and such, the central government in exercise of its power under section 10(1)(d) and 2(a) of the Industrial Tribunal Act 1947 referred the following dispute to this tribunal for adjudication. Whether the action of the management of the Food Corporation of India and their storing agent Sri Tarapoto Ghosh in denying employment to Sri Bhagirath Mahapatra and to
Come to paragraph 4.
My lord. May I read, my lord? The
Yes.
union has stated in their written statement that the concerned 254 workmen were working in the godown at Dankuni owned by Food Corporation of India and were employed by one Sri Tarapada Ghosh, the storing agent, for about 18 years. And more continuously and without any break, those workers were discharging their duties as loading and unloading workers, and the works so done were regular and perennial in nature. And without their services of those workmen, the work at Dankuni godown could not run smoothly. Now, this is an admission.
This is your case. This is the
Yes.
union's case.
Even, my lord, that has been
No, that part is all right.
the next part, madam.
Yes.
Paragraph 5. The Food Corporation of India had its own godown at Dankuni since 1993, and initially, those 254 workmen were directly engaged in storing works by the district manager, senior regional manager, and zonal manager of the Food Corporation of India, and not through some storing agent, namely Tarapada Ghosh. And those process of engagement directly was there from 25/4/1992 to 22/1993, and the Food Corporation of India had taken their services continuously during that period, and all payments were made by the Food Corporation of India directly to those workmen. It is further submitted by the union in the written statement that in case of any dispute differences between Tarapada Ghosh, the so-called storing agent, the FCI management used to make payments directly, and those concerned to 54 workmen, the management of FCI had adopted an unfair means by adopting an unlawful means by recruiting new hands and following the old force to remain idle. The union representing those 254 concerned had ultimately decided to adopt a path of lawful agitation, including approaching the government machinery, that is conciliatory machinery, for necessary redress. The conciliation officer had to take up the matter into conciliation, and ultimately the matter was ended in failure. And the present reference was made by the Government of India, Minister of Labour, such and such. The Food Corporation of India, on the other hand, has stated in their written statement the 254 concerned workmen in reference were never employed or engaged by FCI directly or indirectly. And this was the part of malpractice adopted by Sri Bhagirath Mahapatra, Chonditala Dankuni FCI, storing agent Mutiam Muzdur Union to extract money from the unemployed youths. The FCI had also raised preliminary point about the maintainability of the reference, since there was no employer-employee reinstatement between the FCI and the concerned 254 workmen in the present reference. The FCI also stated in the written statement that the storing agent at Dankuni's godown had been operated by only 22 heads, and the same had no relevance with the activities of FCI Dankuni godown. It was further stated by FCI in their written statement that in view of clause 37 of the storing agent agreement 1985, the system of storing agency had been discontinued, and as such, the contention of the union as pleaded in the written does not hold good. It was further stated that the government of West Bengal has taken over the public distribution system since 1985, and as such, the necessity of reappointment of storing and distributing agents has become nullity, and therefore the liability of absorption of worker storing agent, if any, lies with the government of West Bengal only. The FCI in the written statement further asserted that there were 58 storing agents of Food Corporation of India under West Bengal region, but no agitation has yet been raised by workers working under different student agents excepting the present one. In such view the matter, it is stated that FCI that the claims of 254 workmen under 2 Tarapada Ghosh student agents should not be considered. Both the union and FCI have examined their respective witness. The union has let Sri Bhagirath Mahapat, Secretary and Avani Mohan Bhattacharya, retired assistant grade 3 of FCI, and Anand Chandra Jana, ex-worker of FCI, engaged in the work of loading and unloading of Chanditala Dankuni. The FCI, on the other hand, examined one Somendra Kumar Das, Assistant Manager General, was posted at the office of the District Manager General, who was posted at the office of Hooghly Chinsura. No documentary evidence could be produced by the union, since, as per the evidence of Sri Bhagirath Mahapatta, the union, all the relevant documents relating to this case were destroyed or lost due to heavy flood in his native village at Odisha, where all the papers connected with the case were kept for their safety. The FCI, on the other hand, did not take any plea for not producing any connected documents, but they could examine what witness Sri Somendra Kumar Das, Assistant Manager General, who was posted much later than the relevant knowledge about the working of the workers at Dankuni Goda. On the other hand, the union could produce and examine the witness who were in employment of FCI either directly or in connection with the workings of that working site, that is Chonditala, Dankuni, at the relevant time, and had their personal knowledge. There were 3 witnesses examined on behalf of the union. Sri Bhagirath Mahapatta, Secretary of the union, was examined and has stated in his chief as follows. I happen to be the Secretary of Chanditala Dankuni Mutia Mazdur Union, which espoused this reference. Earlier, I used to work at Chanditala Dankuni siting. I was working there for 20 to 21 years. I used to work under FCI. The district manager of FCI used to make payments to me. I used to work regularly, and the nature of work was perennial. I was engaged in loading and unloading of food grains. FCI has its own godown at Dankuni. I was engaged in the godown itself. In 1993, we were asked to cease work as there was no work left for us and other persons were engaged. Before my removal, no notice was served to me. We had some quarrel with the persons who were freshly engaged. During that period of quarrel with the persons, the work has stopped. Persons like who were removed were asked to go to Andhra Pradesh or Odisha, but I did not go. The district manager was seeking for money to continue with the work, and since he refused to oblige him, we were removed. In 1997, we received a letter from FCI regarding test of endurance. I participated in the said test. I got through the test. Still, I did not get the
One
service.
second. So you have only examined one witness in your favor,
Yes, Madam.
and that too someone who had no personal knowledge.
But only their witness also say that I have seen some person working. Who are those some persons? Malan, I said
That witness is your witness, or your official, your retired official.
but official was their witness.
Yes, he was your retired official.
Their witness.
Their
also-
witness, but he was working with the FCI.
but he could not say that those persons, those list are the workers who are working. So those say, I have seen one person in working and I have seen so many persons.
What about the documents that you have to maintain under the Contract Labor Abolition Act?
But if we have said that, Malado, we have not, these persons have not been engaged, Malado, you have seen that.
Because there is no witness in your favor who has been working during that time. The person who you called as a witness was employed in 1997.
1997, Malado.
Yes. So the entire work was over before that time. The entire period under dispute is before that time.
But question, Malado, main question is this, Malado, there has to be evidential proof that they were working. Nobody from their behalf.
Yes,
And-
because over here, if you see the award, I'll show you. I'll sh- Wait. In cross-examination, see what this person says, Abani Mohan Bhattacharya at page 144.
At page 144.
Yes, page 144, bottom portion.
The B, paragraph B
In cross-examination.
in cross-examination, yes.
Please read.
I used to maintain the attendance of those persons. There were no lower division clerk in FCI at Dankuni. Apart from me, there was another AG3 there. He was S.K. Das. I know Bori ki
Bhagarati Mahapatra was a labor.
Mahapatra as labor Sardar. I learned from the laborers that Bhagarat Mahapatra was running a union. I learned that there was 254 members of union. I have heard that those persons who are working there, Tarapada Ghosh happened to be a storing agent of FCI. I do not know who used to make payment to these 54 persons. I do not know whether they were engaged by FCI, but they are working in FCI. That I know. I do not know.
There is evidence. There is evidence in cross-examination is saying all that.
Well, I shall deal with that.
You have to deal with that
I shall deal with that.
in your reply, because
Yes.
evidence can be either oral or documentary. And he's saying that not in examination in chief, he's saying that in cross-examination.
I shall deal
As
with that.
opposed to that, you have only produced one witness who has been engaged in 1997 after the period of dispute. He has been engaged by the company.
Yes, my lord. My lord, I shall deal with that
One
part.
I have to see whether the industrial tribunal has passed this award based on the evidence, which is based on any kind of perversity, whether there is any infirmity in the decision-making process. Because there is some semblance of evidence in their favor. Whereas the person, if you look at your evidence, look at
S.K. Das, I think.
FCI's evidence, page 146.
Page 146.
Middle of the page, you see what evidence you have relied on. I am working.
I am
Read
working
from
as
there.
assistant manager general in the Putkoso, India, under the district manager Hooghly at Chinsura. I am posted there since 8/10/1987. Presently, I am dealing with the present matter, and therefore I have knowledge of the facts of the case. The matter relates to the year 1990. My knowledge is derived from the documents submitted on behalf of the management. I do not want to add anything apart from the document filed. It is crystal clear from the analysis of the evidence of the witness examined on both sides that the management of FCI totally failed to deny the liability of the concerned.
So,
But that is observation.
please show me the documents that you have submitted on behalf of the management. What documents have you submitted? Because you have to maintain a register yourself.
But my knowledge is derived from the documents submitted on behalf of the management. I do not want to add anything apart from the document
So
filed.
documents, you show me.
I shall, the documents, I shall, these part also I shall reply, my lord.
Because you also have a statutory obligation.
Well, only question is this, my lord, here. My lord,
Because you have to maintain a register.
But my lord, I have to maintain a register of the persons who have been engaged. Well, if my lord, 254 persons who are never engaged, or they are not working as a storing agent of Mahapatra, that whether they are, that is.
Then that he has to say that they were never engaged. That has to come out from his evidence. Because one of your ex-employees have given evidence that these people were working. Now you have to controvert that evidence. Otherwise, the entire evidence that has been given by them, that remains uncontroverted.
Well, I shall think about that. Well, that person.
Right.
I shall think about that.
প্রচুর judgment side করেছে।
এই judgment copy
পরে এগুলো থাক এখন
না, না, দেখাবো না।
You have referred to all this in your notes. Mr. Chatterjee, comma. Learned counsel appears on behalf of the respondent number,
2.
respondent number 2. And submits that the provisions of section 10 of the contract labor within bracket regulation and abolition bracket closed act comma 1970 have not been complied with. The Food Corporation of India within bracket FCI bracket closed full stop. He refers to a special bench judgment of the Supreme Court of India reported in 1997 within bracket 9 SCC 377. It just এটার cost title টা করে দেবেন to contend that the purpose of the said act is not to cause economic ruin and economic death to the contract laborer and his dependents. Full stop. It is for the purpose of amelioration of the contract laborer that section 10 of the 1970 Act was passed. Full stop. In the event the laborers are doing the work of a perennial nature, then they cannot be thrown out of the establishment, lock, comma, stock, and barrel. Full stop. Though the legislature expressly has not mentioned the consequences of abolition of contract labor, but the very scheme and ambit of Section 10 of the Act clearly indicates the legislative intent of making the erstwhile contract laborers direct employees of the employer on the abolition of the intermediary contractor. Full stop. Next. Mr. Chattopadhyay, learned counsel, appears on behalf of the petitioner, stroke FCI. Full stop. He is permitted to take necessary instructions on the issue relating to the evidence given by the sole witness who was examined on behalf of FCI. Full stop. The said witness has deposed that his knowledge regarding the facts of the case are derived from the documents submitted on behalf of the management. Full stop. Mr. Chattopadhyay is required to submit as to the nature of the documents relied upon by Mr. Das in giving his evidence. Full stop. Such instructions are pertinent for adjudication of the present writ petition, since the only witness produced by the FCI was appointed by the company on October 8, 1997, and had no personal knowledge about the facts of the case, since the issues raised therein relate to a period between 1982 to 1993. Full stop. Next, let the matter appear under the same heading parted. On July 19, 2023.
July 19, my lord. You should kindly give me some time because those documents are old. Well, I have to.
I don't want to because otherwise, this pending for a long time and you should be prepared with your
Well, I know.
documents by
Well,
now, because if I now give a longer date, I'll be forgetting what, after so much of judicial time being spent, I'll be forgetting what
as a lord,
I have
I shall try.
perused today.
I shall try one. 19th July.
Because these documents should be there in your records, because his entire deposition is on these documents. Must have been produced before the tribunal. Look into the writ petition more closely and see if these documents are there in the writ petition.
I shall see. My lord, that
He has no personal knowledge and his
he has said
evidence
so.
is only based on these documents. And he has not controverted.
I don't want to work.
Orally also he has not controverted.
Well, I shall, on the reply, Malal, I shall take care of that one.
Grateful.
Malad, I am appearing for the respondent number 2.
Today we don't have much time because I have an original side matter at 3:30 start.
Last occasion directed me to submit the written notes,
Yes.
but I am ready with that. But what Mr. Mukherjee is saying, I don't know.
So I'm extremely sorry, Lordship. Last occasion I could not attend at the time of hearing, Lordship. Lordship, this is my written note.
It's completed.
But yes, my lord, I don't
Lordship,
want
in the streaming, Lordship, I have
Lordship precious time more. My lord, I have what I am submitting. Their probationary period that has been terminated within 2
Yes.
months, but that is the.
Lordship,
but I
in the
have
streaming, Lordship, so far I got the points of my learned senior friend. Lordship, kindly give me a 5 minutes time to reply to that effect. Nothing else.
Yes, should start.
This is my written note.
His main point is that you cannot
That is written on.
hold the respondents to carry out an entire disciplinary proceeding because this person is still on probation. That is the main thrust of his argument.
Written argument with
And the provision of appeal also. According to them, there is a provision of appeal.
with judgment. But that has not been considered by me. That is a provision for appeal. That is preliminary point has been taken before the other bench. But that before your lordship's bench, but I have not taken that point.
Now the entire thing has been considered on merit.
Yes, my lord.
Before the other bench, what did the other bench say?
That is kept on open by my Lord Justice Ashish Chakraborty.
One second.
That is a provisionary period,
What did you
Katena
say?
judgment. But I have submitted with that judgment that at the time of probationary period, that can be done. Now I don't know what Mr. Mukherjee is saying.
There is no
After 1
recording
year,
that,
that
wait.
petition filed.
Mr. Basu, there is no recording that the preliminary point has been taken in the order.
Yes, the judgment is there. That is the order.
Is the
passed.
point of maintainability of the writ
Amal
petition
Kanya.
shall be decided already.
But before losses, that point I have not taken.
Yes.
Lordship, kindly come page 15 of the writ petition. This is an appointment letter.
Page?
Page 15 of the writ petition. I am restricting to the Lordship in reply what they have.
Yes.
Lordship, second paragraph, you will remain on probation for a period of 1 year with effect from the date on which you join the post regarding the probation, confirmation and other condition of service. You will be guided by West Bengal Services Security of Services Act 1975
and rules made thereunder, and in addition to government order, rules, statute, regulation, rules, ordinance, etc. of the University of Kolkata. Now, Lordship, this was the appointment letter. Now, Lordship, it is already, I have submitted that, Lordship, they have taken the resolution on 17th, and this resolution has been taken, the petitioner will be terminated. 25th so-cause notice has been issued. And on the basis of the so-cause notice, I given the reply. And Lordship, without considering the reply on March, Lordship, that is the kindly come to the termination letter. That is the writ petition. In the writ petition, I have annexed. That is 29th March 2017. The termination order has been issued. So, Lordship, my condition, this is absolutely violation of natural justice. So, even if it is probation, the petitioners, the so-cause notice, when it has been issued, it ought to have been issued before the decision of termination. So, Lordship, this is an absolutely violation of natural justice. Now, Lordship, kindly come in my written arguments. I have annexed in judgment paragraph number 14 and 15, page
Yes.
22. Kindly come page 22. This is Whirlpool Corporation versus Register of Trademarks.
Yes.
Kindly come. I'm just reading lots of relevant portion. But the High Court, I'm reading paragraph 15, that the High Court has imposed
Wait. Page number?
page 23.
Yes.
But the High Court has imposed upon itself certain restriction on which is that if an alternative and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, namely where the writ petition has been filed for the enforcement of any fundamental rights, or where there has been a violation of natural justice, or where the order or proceeding are wholly without jurisdiction or virus of an act is challenged. There is a plethora of a case law on this point, but a cut down this circle of forensics Whirlpool, we have rely on some old decisions of the evolutionary era of the constitutional law. They still holds the field. Now, Lordship, this is fact that this is a violation of natural justice. Resolutions taken. After the resolution, so-cause notice has been issued, then Lordship, the termination order. This is a clear example of the violation of natural justice. Now, Lordship, kindly come. Lordship, my contention is, as per the appointment letter, the statute, university statute is also applicable. Now, Lordship, kindly come. I'm just showing 2 university statutes. Kindly come page 48. Page 48 of my compilation. This is University of Kolkata. Also, the Baharampur College is affiliated under the University of Kolkata. Statute 11 CT 4D, middle portion. ST 11 CT 4D. This is University first statute. However, before initiating such disciplinary action against an erring teacher or principal, the governing body of the college shall try to initiate.
Baharampur College is affiliated with
Yes,
Kalyani University.
Kolkata University. Yes, this is admitted. The principal of the governing body of the college shall try to initiate a corrective measures if the injury caused by the offending act is minor. The offender may be let off with a written caution. The particulars of the offending act, however, shall be recorded in the service book for the future reference. So, Lordship, what is my allegation? That I am a librarian. Lordship, the concerned principal has requested me that I have to done some coordination work in the college.
I am not here to assess the punishment with the gravity of the offense.
Now, Lordship, this is the remedy was available to them. they have not exhausted this.
The question is whether there is any violation of the principle of natural
Yes, that is
justice.
one of my grounds. But Lordship, even there was a remedy that for the minor offense, they can give me caution to that effect. Even I say that petitioner has reluctant to doing the Konyasri work. Now, Lordship, kindly come page 45. This is another statute, Kollan University First Statute.
Mr. Mukherjee, you have to complete on the next day. All right, you place that, but you have to conclude on the next day.
Lordship, the only this is,
Has been made by you.
I mean, this is apart from this act, Lordship, where the probationary officer, as per the university statutes, says that even before imposing a penalty of the discharge from my service, the reasonable opportunity of hearing and inquiry ought to have been done. Kindly come
Yes.
page 45. That is statute 11 CT 4A. No order of imposing
One
any.
second, from when were these rules applicable?
Kindly come page 45. Middle
wait.
portion, no order. This is University First Statute,
Wait,
page 45.
these disciplinary rules, these guidelines were applicable from when?
So this is applicable. This is a university long. I also bring the book also. This is no order of imposing any penalties mentioned in paragraph 3 shall be issued without informing the teacher concerned the charges against him and giving him an opportunity of being heard, and except after inquiries held as per the principle of natural justice. So, Lordship, it is not guided by this is the university statute. Lordship, this procedure ought to have been maintained by the concerned college.
Addition. Statute of Poland. Additionally, mainly will be power of forest agency. In addition to only appointmented addition.
Yes.
First day judgment. Paragraph 14 and 15 concept of probation discussed. Probation is published, employer has the right to terminate.
Whatever the
With-
first point,
with-
GB meeting, body meeting, 2 times held. But what my
On the microphone.
17th January 1 and another is 7th March. My Lordship kindly, my learned friend referred the page 18, kindly see page 18. Writ petition.
Yes.
That is this is to inform you that as per the decision of the governing body taking in its meeting held on 7th March 2017, not that first meeting, discussed the that is discussed and the decision caution has been given to that petition.
Where? In the first meeting only you have made up your mind.
That is
Have
the
you not made up
resolution,
your
that is the
mind?
opinion. That is the second meeting held on
You are
7th
proceeding
March.
with a closed mind. You see the language of the first meeting. See the language of that meeting.
Yes.
Well, your Lordship knows that the SOCAS is not a statutory obligation regarding the it is only for
Even
the
if
sake
he
of
is in a
natural
pro-
justice.
Even if he is in the period of probation, even if you do not have to comply with the entire disciplinary proceedings, there has to be some application of the principles of natural justice. Look at the language of the first notice.
The second body, general body meeting on 7th March, not the one meeting has been held. That is the 7th March 2017. And the letter issued to him are 9th March 2017. And that is the clearly written there. As per the decision of the governing body taken in its meeting held on 7th March 2017, your service as assistant librarian is not required and hence terminated with effect from 8th March 2017 FN. Forenoon. What I am placed before Lordship, the judgment with the written argument, that is in the first judgment, paragraph 17, it is discussed regarding the probation. I read it.
Last meeting, ekdam totally.
I read it.
We'll continue on the next day.
Lots. Lots of next Wednesday.
Ash, Mr. Basu, learned counsel appears on behalf of the respondents and makes his submissions. Mr. Mukherjee, learned counsel appears on behalf of the petitioner and opens his submission in reply. Full stop.
No,
Notes of arguments are handed over.
Lots, I have to say something, lots of on the next.
I
day.
said you have opened your submission in reply.
I'm sorry. Lots.
Handed over, handed over by the parties are retained with the records. Full stop. Let the matter appear for further consideration under the same heading, part heard. On July 19, 2020.
Petition as a written argument, আমাদের copy দেয়। State চাইছে। State চাইছে।
Lord, I have made submissions in a detailed manner. Only the judgments which have been cited by Mr. Court, that I will be taking. On the last occasion.
Yes, you did not make any commitment.
Yes.
On the occasion previous to that, you made commitments of 5 minutes. Last occasion, we all become wiser, Mr. Bhattacharya.
We all become wise, Willard, every day.
Yes. Constitution.
Yes. Lord, I may also hand over. Yeah. For a second, Lord, kindly peruse Article 229. Article 229, sub-article 2. Subject to the provisions, sorry.
Yes.
Subject to the provisions of any law made by the legislature of the state, the conditions of service of officers and servants of a high court shall be such as may be prescribed by rules made by the Chief Justice of the High Court or some other judge or officer of the court authorized by the Chief Justice to make rules for the purpose. Now, Miller, I should be drawing to my lord's kind attention that the judgments which have been referred to by the High Court administration, that also I have perused that also says that you should prescribe rules and thereafter you should follow the steps to be taken. And relying on the earlier judgments, Miller, I find that the Supreme Court had delivered a judgment in year 2014 Supreme Court 2175. And I'd be referring to my lord paragraphs.
In reply, you are citing this judgment.
No, I was saying this because, my lord, I only want to indicate to my lords that unless rules are framed, you cannot act or proceed under Article 229 in any manner you want. And, my lord, the Supreme Court has also observed that this cannot be done in an arbitrary manner. In order to repel the contention, I was only, my lord, making this submission. And, my lord, I was relying upon the last judgment. I have nothing more to submit. This is, my lord, I acted. Thank you. Your lordships may kindly consider, my lord, paragraph 29 and 35. That's all. Now, my lord, the applicability of a judgment, my lords have laid down the law that it depends upon the facts and circumstances of a particular case and what can make a world of difference. Therefore, my lord,
29, please place.
my lord, I was paragraph 29 and, my lord, 35.
29 and 35.
And 35 of year 2014 Supreme Court 2175.
No, what happened to 2014-14 SCC?
Yes, I am placing before my lords, my lord, year 2014, year 2014
decision.
Supreme Court 2175.
Same decision.
Same. এটা একই তো নাকি না এটা অন্য হয়ে যাচ্ছে
What is the cause title?
my lord, the cause title is Renu versus
Yes,
District
yes,
and
same
Session
decision.
Judge Peace Hajari.
Same decision. Paragraph numbers are same. Please
Para-
read the paragraphs.
my
you're
lord,
relying on.
ওইটার থেকে একটু দেখে নিতে হবে whether this is matching with this.
ওইটাকে দিয়েছি তো কোনটা ওকে যেটা হ্যাঁ আরে আমি দাঁত ফাঁক দিয়ে ফেলেছি দেখে নেবো তোমার দাঁত দাঁড়া 29টা পড় না আমি
29.
হ্যাঁ
Thus, in view of the above, paragraph 29, it starts that thus in view of the above, the law can be summarized to the effect that the powers under Article 229, sub-article 2 of the Constitution cannot be exercised by the Chief Justice in an unfettered and arbitrary manner. Appointment should be given, should be made, giving adherence to the provisions of Article 14 and 16 of the Constitution or such rules as made by the legislature. And, my lord, your lordships may kindly, my lord, I kindly take pains, my lord, to come to paragraph 35. In view of the above, the appeal stands disposed of with the following directions. All high courts are requested to re-examine the statutory rules. Here, Milord, I am just placing an emphasis to re-examine the statutory rules dealing with the appointment of any staff in the High Court as well as in the subordinate courts. And in case any of the rule is not in conformity and consonance with the provisions of Article 14 and 16 of the Constitution, the same may be modified. To fill up any vacancy for any post either in the High Court or in any courts subordinate to the High Court in strict compliance of the statutory rules so made. In case any appointment is made in contravention of the statutory rules, the appointment would be void ab initio, irrespective of any class of the post or the person occupying it. The post shall be filled up by issuing the advertisement in at least 2 newspapers, and one of which must be in vernacular language having wide circulation in the respective state. In addition thereto, the names may be requisitioned from the local employment exchange and the vacancies may be advertised by other mode, also etc. employment news. Any vacancy filled up without advertising as prescribed herein above shall be void ab initio and would remain unenforceable, and advertising as prescribed herein above, I'm sorry, Milord, and inexecutable except such appointments which are punishable to be filled up without advertisement, that is appointment on compassionate ground as per rules applicable. Before any appointment is made, the eligibility as well as suitability of all candidates should be screened or tested while adhering to the reservation policy adopted by the state, etc., if any. Each High Court may examine and decide within 6 months from today as to whether it is desirable to have centralized selection of candidates for the courts subordinate to the respective High Court, and if it is found it is desirable, may formulate the rules to carry out that purpose either for the state or on zonal or divisional basis. The High Court concerned or the subordinate court, as the case may be, shall undertake to the exercise of recruitment on regular basis at least once a year for existing vacancies or vacancies which are likely to occur within the said period, so that the vacancies are filled up and thereby avoiding any inconvenience or shortage of staff as well. Milord, I am just drawing this thing through my lord's kind attention, and I should submit to my lord, at the cost of repetition, kindly to excuse me, that no rules have been framed by our court in respect of filling of these posts. Now, these are, and so far the judgments and concern, and I made extensive arguments, and your lordship may kindly consider that the written submission which was made by which was submitted by the administration before this honorable court, I am not aware whether the judgment which my learned friend has also placed, Mr. Ghosh has placed before my lord's, in respect of one judgment, that unequals cannot be treated as equals. I am not aware whether that judgment has been. Since my lord, yes, I'm sorry, my lord, I just only make one appeal to my lords that your lordship has given me sufficient time. My lord, if I have left out any point, kindly allow Mr. Ghosh, my lord, for 5 minutes. For 5 minutes, I just, my lord, I appeal to my.
Just give me 5 minutes.
Yes.
My learned friend has said everything, but
2 minutes.
2 minutes. The minutes
Just
of,
give me. I'm just going through the judgment.
the other judgment.
Yes. The one that you have placed just now.
Yes.
Yes, Mr. Ghosh.
The minutes of 11th November,
Yes,
2019, this was not with us when we filed the writ petition.
yes.
So that is why only two submissions I want to make in respect of this. Your Lordship may recall the facts have been stated. We prepared a list of dates also. After this the meeting was held, immediately thereafter in December 2019, the petitioners asked for a copy of the minutes. Those are in our supplementary affidavit. We have given those letters. We were not given this minutes. Then we made RTI. They said our promotee post is deputy registrar. And the stamp reporter's promotee post is assistant registrar.
Yes.
So what we tried to establish through our representation is that we belong to two different hierarchies, or at least whatever the hierarchy, I am a higher. So it's in effect, the stamp reporters are getting a double promotion. And not only to the so if my lord in that light takes up the 11th November meeting minutes, my lord, if my lord sees the first page, the reason for this meeting was earmarking of 3 newly sanctioned posts of deputy registrar original site and assigning specific nomenclature in respect of each. Now, what were these 3 posts? If my lord turns over the page, these were the existing posts. In the first box in the second page, these were the existing posts. There was deputy. We are only concerned with court and judicial.
Yes.
The others are not, we are not concerned. So this was the post, and the feeder post was only the assistant registrars. They say that. Then they say that 3 newly sanctioned posts have come. Then the last paragraph, the post of deputy registrar is the promotional post of assistant registrar. And hence the following posts may serve as feeder posts. So the assistant registrars from 1 will be the sanction 6. They are to be deputy registrars, even for the new post. As it is the existing post, we were already there. And for the new post also. Thereafter, my lord, there's a discussion on the pay, etc., not important. If my lord comes to the stamp report after paragraph 11, it becomes paragraph 1 again. Now, how this subject came into this meeting, because the meeting was for deciding on these two posts, the nomenclature and who would be the feeder post. Now, then, my lord, the stamp reporter, but I'm only citing this, my lord, because my learned friend has submitted that the reasons are given in this order itself. It's a bit of a circular reasoning. I'm not given the order, and you said no, the reasons are already in the order. The Chief Justice has no obligation to give you any reasons. But this order was not with us. When now your lordship will see what is wrong with this, then the feeder post, the conventional feeder post is recorded there. Then they say the problems with the stamp reporters. So they have a blind alley. If my lord comes to paragraph 3, the post of stamp reporter is a blind alley post, etc. What the committee hasn't been shown is they had earlier applied for a promotee post, and which was rejected. RTI, we have shown, my lord, the stamp reporters had wanted there should be some enhancement in their lives. We have no grievance against that. Then, if my lord comes, then he says that if I appoint only for stamp reporters, it will be unfair. There are only 2 of them. So they decide on option B. So from paragraph 6, 7, and 8 only I'll rely. So far as option B is concerned, the only in 1974. So the chapter 6A, I think, well, there explains they only have the duty to examine documents. Now, this analogy, because they have relied on the Chief Justice had earlier approved of clubbing together these 2 posts, my lord, for promotion of assistant registrar. In view of such approval, the appointment on promotion in the post of assistant registrar is made from a field of selection comprising out of superintendent, grade 1, and section officers. Well, we had taken out an RTI later. Well, they show that they are below the class. Obviously, they are below the class of assistant registrars, and they are from the same group. Therefore, there's a big difference between us. By substituting superintendent as assistant registrar and section officer as stamp reporter, the analogy doesn't work, at least as far as the principle on which we are before, my lord. Then the stamp reporters in the original side, like assistant registrars from legal professions, are law graduates who are recruited from the legal profession through open recruitment test. And the first important thing is this test is separate. They have different qualifications. So the stamp reporter has to be very fluent in the vernacular because they will have to examine documents, etc. Their duty is restricted to examining documents. Whereas an assistant registrar, my learned senior has already said, they have a whole array of duties, quasi-judicial, administrative, officiating, etc. So the tests are different. The entry-level tests are different. That's my point. Then the recruitment rules in respect of both cadres are more or less the same, but they are not the same. Because in the appellate side, it's clearly distinction between class 1, 2, and 3. And in the original side, though they don't have the mention of them in the rules, the stamp reporters, when we took out the RTI, they said the promotee post is assistant registrar. So they have to come and become assistant registrars. Then they can go forward. More or less the same. Of both perform court-related duties. We took pains, my lord, to show all the provisions of the original side rules where the duties are completely different. They're very different. Then both the stamp posts of the stamp reporter and assistant registrar are born with the same pay scale. But we are not concerned with the pay scale, but as a matter of fact, we get the assistant registrars get a bit more.
200-300 rupees more. Now, paragraph 8 is important, madam. We are therefore of the view that the stamp reporters original side may be considered in the field of selection along with assistant registrar for the purpose of appointment on promotion in any future vacancy in the post of deputy registrar, court and judicial. This was the existing post.
Yes.
So they are coming into both. It's not that a new post is being done only to help them get promotion. So they are coming, they are also eligible for both the posts now, court and judicial and legal, or any new post of deputy registrar, which may be allotted to the cadre of direct recruit from the profession. Then the eligibility of the officers shall be based on seniority in the High Court service. Now, as far as seniority is concerned, we have already mentioned, Manan, that they are on a higher pedestal. Now, the only point I wanted to make, because my learned friend submitted that these were the reasons. Our grievance was immediately, even before we got this, when we heard about this, we made our representation. It's been rejected. My learned friend has not shown us at least what was the Chief Justice's reason for rejecting our petition. So it cannot be that it's an empty formality, because we have made there is a distinction between us. And just finally, I would want to just reiterate, my lord, that judgment has shown, my lord, the 1994 Supreme Court. Just one paragraph that it can be solved. Yes, if 1994 2 SCC 411, paragraph 12 and 14 I had cited.
1 second.
No, 411. 41. Paragraphs 12 and 14, nearly identical facts. Two different class people were getting.
1994 2 SCC.
No, I don't want to show this. This judgment we had cited has not been dealt with, but this is the basic principle why we are coming before my lord. I've read 12 before, the last 3 lines, why that particular rule was bad, which was under consideration. It violates Article 14 since it treats unequals as equals, and what is more, gives unwarranted advantage to the incumbents of the lower post over the incumbents of the higher post. Now then, at paragraph 14, we have no doubt that whatever the anxiety of the High Court to provide promotional avenues to those who are stagnated, the promotion rule will not be made in any manner which would deny to the incumbents of the higher posts promotion while giving unmerited advantage over those holding the lower post. The necessary consequence is the promotion given to R2 stands quashed. So that is the difference, that we are being treated unequally. My learned friend said that now our chances are better mathematically. 8 is to 2 is better than 6 is to 1. But if it is not 8 is to 2, it would be 6 is to 2. And my chances would be much better for both the posts if I was there. But we are really aggrieved about the new post and the back door, how the stamp reporters are coming into both the posts. So that is the only clarification I wanted to make. As far as the judgments are concerned, my lord, which my learned friend cited, all of them were to do with in the same cadre. The first one, the Chaurasia judgment, in the same cadre, there were 2 unequal payments. And the Supreme Court did not interfere. They said that they are best to decide. The committee is the best to decide who should get more, depending on the merits of those persons. As far as we have prepared a note, can hand it over. But if my lord takes the 1989 judgment, but as far as these 3 judgments, my point is that none of them, every case has to be dealt with on the facts. None of these cases talk about promotion from unequal. I think the case that we cited is more aligned to the facts of this case. They were to do with other principles. If we have prepared a note, my lord, But as far as the case law is concerned, that I didn't include in the note. And if I may give that the distinguishing features, 2-page note on that, and we have other notice here, man. This side, easy. This is our note. This is just a comprehensive note, man. If my lord sees the relevant facts we have set out, it's like a list of dates. So if my lord comes straight away to page 5, that's where our submissions are recorded. Those, for my lord's convenience, we have put the page numbers, etc. And from paragraph 5 is our submissions and the law that we have relied on. And we have summarized my learned friend's argument, which was only that the reasons for clubbing the posts have been given in 11th November. And the other argument is the Chief Justice is superior, has supremacy in deciding these things without any requirement for him to explain or give reasons. But exercising a legislative power, I'm not challenging that. Of course, he has the power. But once he's exercised it, if the order I want to challenge, I'm allowed to challenge. And no rule has been made as far as this is concerned. So those points we have. In all the matters that my learned friend, those 3 cases he cited, they were concerning rules. Even the matter that I have cited, it concerned the rule was made, the rule was quashed. Here there is no rules. Only thing I want to explain, my lord, from page 10. Page 10, my lord, is the submissions my learned senior made on the last day. So there might be a bit of repetition with my note. I didn't want to touch his note, so I've kept his note. So we are being a bit easy. So, তুমি তো আমার কাগজটাই ফেরত দিচ্ছ না আমার হচ্ছে আমি মার্ক করে ফেলেছি জাজমেন্টটা তো দিয়েছিস ওরা তোমরা নোটস দিয়েছো এটা দিস কাগজ তুমি নোটস দাও But just they have not given any notes as far as I know. The one দিয়েছো না জজ সাহেবকে দিয়েছো নো হ্যাঁ তোমাদের দাওনি You've given it except for to Mr. Bhattacharya and me.
Lord, may I just deal with the last case that has been cited in reply? Lord, kindly see paragraph 2, paragraph 1 first. Kindly see paragraph 1. The matter initially related to the appointment of class 4 employees in the courts subordinate to Delhi High Courts. As the dispute arose about the continuity of the employees appointed on ad hoc basis for 89 days, which stood extended for the same period after same interval from time to time. The matter reached the Delhi High Court and ultimately before this court. This court, with an order dated such and such, took up the matter in larger perspective, taking cognizance of perpetual complaints regarding irregularities and illegalities in the recruitment of staff in the subordinate courts throughout the country, and in order to ensure the feasibility of centralizing these recruitments and to make them transparent and transferable. This court suo motu issued notice to the Registrar General of all high courts and to the states for filing their response mainly on 2 points: why the recruitment be not centralized, and 2, why the relevant rules dealing with the service conditions and the entire staff be not amended to make them as transferable as transparent it should be, transferable post. All the states and the high courts have submitted their response and all of them are duly represented in the court. Then Lord, please take note of paragraph 3. It was in view of the above that this court, with its earlier orders, had asked the learned counsel appearing for the states as well as high courts to examine the records for their respective states courts and report as to whether a proper and fair procedure had been adopted for evaluating the candidates. A mixed response was received from different councils on the issues. Then your lordships will kindly see there is a discussion of article 14 and 16 because Lord, the main allegation was that these employees who are engaged on temporary basis are being recruited or extended, their tenure is extended. Now, Lord, ultimately, your lordships will find paragraph 17, where they say that in public posts, the article 14 and 16 should be complied. And then Lord, your lordships will see paragraph Lord 29, which my learned friend read. Says, thus in view of the above, the law can be summarized to the effect that the powers under article paragraph 29, my learned friend.
Yes.
After Lord considering all the judgments on article 14, 16, because Lord, after Uma Devi, the law is consistent that in public employment, there has to be Lord an advertisement, wide advertisement. Everybody should get equal opportunity to apply. That all those concepts are Lord taken into consideration. Then Lord 29. Thus, in view of the above, the law can be summarized to the effect that the powers under 229(2) of the Constitution cannot be exercised by the Chief Justice in an unfettered and arbitrary manner. Appointment should be made giving adherence to the provisions of 14 and 16 of the Constitution and or such rules as made by the legislature. Then, Lord, please come to paragraph 34. We would like to make it clear that the High Court in its constitutional and autonomous authority is subordinate to none. Therefore, nobody can undermine the constitutional authority of the High Court, and therefore the purpose to hear the case is only to advise the High Court that if its rules are not in consonance with the philosophy or constitution, then the same may be modified and no appointment in contravention thereof should be made. It is necessary that there is strict compliance with appropriate rules and employer is bound to adhere to the norms of article 14 and 16. So look, basically this judgment says that if there is a rule, follow the rule. Whatever the rule is, follow that. It does
And the
not
rule cannot be against the article 14 and
14
16
and
of the,
16, follow
it can't be derogated the principle,
that is the
the
basic
articles
principle.
of
That is the basic
constitution.
principle. And Lord, here the case was a case of admission. It's at the entry point. Entry point of class 4 officers. That was how the matter went. But Lord, the Supreme Court looked at it from a broad perspective and said that this should be the principle. And that has been the principle, Lord, throughout. Now, Lord, so far as our rules are concerned, first, Lord, this is
One thing I wanted to ask you, apropos Mr. Bhattacharya's submission, that under, you cited Article 229(2) of the Constitution,
Yes.
and you submitted that the Chief Justice has unfettered discretion to make the rules regarding the staff of the High
Correct.
Court. But he submitted that it is only an unfettered discretion as far the rules are concerned,
correct.
but not as far as the other administrative orders or decisions are concerned.
Lord, kindly take note of Lord 2001 volume 9 SCC, which I cited. Lord, 2001
2000?
volume 9. I had cited Lord to show that it is not, rule making is not necessary. Even Lord by administrative order.
2001 volume 9.
Yes.
I should be having it. এখানেই আছে, দেখো তো ওখানে।
Copy দেওয়া হয়? Copy দেওয়া হয়?
সাইট করলে তো থাকবেই এখানে।
This making of a rule,
Just 1 minute, let me
I'm so
just-
sorry.
এখানে এর ভিতরে। 2001
It's a
volume-
2-page judgment, Lord. 2001 volume 9 SCC 76.
আচ্ছা, এর ভেতরে নেই 2001 volume 9
দিয়েছিল। কোথাও এদিক ওদিক নাই। আজকে আমাদের
এখানে দেখো, দেখুন তো সব কটাই তো আছে এখানে দেখি 2001 volume 9 এটা ওখানে ওটা না।
maybe Lord on that day, Lord, the
All right, cite from here. please,
just Lord, take note of paragraph 2.
Paragraph.
2.
Yes.
The full court judgment that our High Court has delivered, there also, Lord, there is discussion. Your Lordships will find that the appointments to the post of private secretaries in the High Court could be made by the Chief Justice as indicated under Article 229 of the Constitution. In the absence of rules framed by the court or the learned Chief Justice, the direction of the learned Chief Justice operates in the field of appointment. That being the position, Chief Justice was well within its jurisdiction in deciding the norms of merit cum seniority for filling up the post of private secretary, etc. What I am relying on is that even a direction of the Chief Justice is sufficient. The formal making of a rule is not necessary. It's not a sine qua non in under Article 229. That was my argument, Lord, initially. And I have covered it, Lord, in my notes. Lordship will find that. And Lord, on this question of assistant secretary, etc., I don't want to repeat, but I have shown that it is there in the appellate side.
Yes, yes,
Am-
assistant registrar.
Assistant
Mm.
registrar. And Lord, in the original side, that is not so. So Lord, when they rely upon that right to information
Yes,
reply,
yes,
it is relatable to the appellate side.
yes.
These are my Lord. Okay.
আমার ফ্যাক্টস গুলো অলরেডি হয়ে গেছে, আমি জাস্ট ফাইন্ডিংস গুলো আমি চেম্বারে চলে আসবেন, আমি দিয়ে দেবো। আমার এখানে পেন ড্রাইভে আপনাকে দেওয়া নোটসে অলরেডি ফ্যাক্টস গুলো পড়া আছে, হয়ে গেছে আমার পেন ড্রাইভে। আমার হ্যাঁ, আমার সেন্টিনারি বিল্ডিং এর চেম্বারে চলে আসবেন, আর পেন ড্রাইভ থেকে আমার ইয়ে থেকে নিয়ে নেবেন, মানে বেশিরভাগটাই করা হয়ে গেছে সেন্টিনারি বিল্ডিং এর।
Much
অলরাইট, আচ্ছা আপনি চলে আসুন, আই শ্যাল